Good afternoon, everybody. This is the program on constitutional government at Harvard. I'm Harvey Mansfield. I'm here with my wife, who's a co-director, Anna Mansfield, and also Andy Zwick. Our guest today is Adam J. White. Adam J. White is a senior fellow at the American Enterprise Institute in Washington, where he holds the Laurence H. Silberman Chair. He specializes in constitutional and administrative law. He got his BA from the University of Iowa and JD from Harvard Law School. He's also, too, at the Antonin Scalia Law School at George Mason University. There's a difficulty there. Antonin Scalia was an originalist Supreme Court justice, famous for that, taking that position. George Mason, though called a founding father, actually refused to sign the Constitution. But he was the author of the Virginia Declaration of Rights, and is therefore included, I think by courtesy, as a founding father. Anyway, we don't need to go into this distinction anymore.
We don't know how long his name will be on the school anyway.
Today, all right. So, and Adam White is also on the Leadership Council of the American Bar Association. He was most recently in 2021 on the President's Commission on the Supreme Court of the United States. He writes on constitutional questions, often in the Wall Street Journal, but also commentary. He was the constitutional law commentator in the late lamented Weekly Standard, and he testifies to Congress very frequently. Books, well, I have to tell you, first place, he's not the Adam White who is the author of a book titled The White Man's Guide to Dating Black Girls. So he's not going to be talking on that subject, unless you want to improvise some remarks.
I think I'll stick to the script.
Yeah. All right. But he's the author of a book that's coming out, a co-author, called Natural Rights, the Common Good in the American Revolution, co-author with Yuval Levin and John Yoo, coming out from AEI. And his topic today is, after the everything election, what the next 6 months will show us yet again. So, Adam White.
It's such a pleasure to be here. I was here almost 2 years ago talking about the Roberts Court and administrative law and the administrative state. I had any number of predictions about what the future held, and I think I was basically right. I think I'm going to stick with my perfect record and not predict what's going to happen next week. I don't know. You don't know. We don't know who will win next week. But we do know what will happen in the 6 months after that, and that's what I'd like to talk about. What I'm about to describe is so familiar, it will seem banal. But my goal here is to unpack the next 6 months and point a little bit back into the past and a little bit further into the future. Next week is the everything election. Every 4 years, America holds the everything election. In one presidential election, everything seems to be at stake. Every policy of consequence, every future judicial nomination, the basic temperament of our politics in our country. Every 4 years, we elect one person who represents or is taken to represent all those things, and who has broad power to pursue all of those policies for reasons we'll get into a little bit later. So when the next president is inaugurated in January, there will be a burst of energy. Before the inaugural balls on Inauguration Day are even completed, new executive orders will be signed. Those things have already largely been drafted. We just need to know which president's drafts will become the new law of the land. Executive orders will be signed beginning on January 20th and for weeks to come, announcing any number of new rules and policies and goals and principles. And if you like rules, there's a lot more where that came from, because in the months to follow January, we'll see the new president's agencies issue a flurry of new regulations. they'll take down old regulations just as the new president will take down old executive orders. But the agencies for the first 6 months will be a burst of policymaking energy. But then what happens? As soon as the ink is dry on any one of those things, every executive order of consequence, every new regulation, the moment it is signed, there will be a lawsuit. If President Trump wins or former President Trump wins next week, the lawsuits will be filed in federal courts in Massachusetts and in California, maybe Washington, Hawaii. If Vice President Harris is elected president, the lawsuits will mostly be filed in Texas and other red states in the federal courts there. And the federal judges will jump into action. They will be called upon immediately to freeze things in place. They'll issue injunctions, and not just an injunction that involves the party at hand or the parties at hand, but nationwide injunctions, where one federal trial judge will or will not issue a decision very quickly that freezes this federal order or regulation in place immediately. I won't bore you with the legal details, but take it from me, a former lawyer, a recovering lawyer, that when a judge issues an injunction at the front end of litigation, the case is filed against the president or the agency, and the court quickly has to decide what to do. The decision is partly about law. The judge has to decide who seems to have the better of the case, the better reading of the law at the outset. But there's also a number of prudential factors. Injunctions are part of what we call equity. So it's a question of who's injured right now. Who would be injured right now if I froze this executive order, didn't allow it to go into effect? What's the broader public interest? So the job of these district judges, as they very quickly issue these preliminary injunctions, is a mix of legal and prudential considerations. And that'll carry on for months and months, I guess, as I said. The moment the ink is dry on a new executive order or regulation, there will be a lawsuit and possibly a nationwide injunction. So where's Congress in all of this? Well, Congress is doing what it always does best, watching and waiting and complaining. There might be some legislation in the first, say, 100 days. That's, of course, the original first 100 days of Franklin Roosevelt's first term, where he worked with Congress to pass a tidal wave of new laws. It's possible that will happen if President Trump is elected with a Republican Congress, or if President Harris is elected with a Democratic Congress. You might get legislation. You might especially get legislation around spending. But regardless of whether the White House and Congress are in the same party's hands, the prime energy of policymaking will be the president and his or her administration. And Congress's job primarily will be to hold hearings. They'll hold lots of hearings, either hearings to criticize the new administration or hearings to criticize the administration's critics. They'll hold these hearings. The members of Congress will make statements. They'll make their opinions known, and these opinions will be sent out to the world through YouTube and Twitter. Maybe over time, Congress will write some reports. This or that committee will issue a very sternly worded report with all sorts of accounting of the facts that have happened, and who's right and who's wrong. And then eventually things will sort of peter out. 6 months, 8 months into the administration, everything will slowly grind to a halt. There will still be hearings. Presidents will still make statements. But things will become much slower, and eventually they'll become, I like to say, very passive-aggressive. The president will still be done issuing rules, and instead she or he will start making statements, trying to cajole the public to do this or that. I wrote an essay for Commentary Magazine a few months ago saying that the Federal Trade Commission in the last few years has been very passive-aggressive. The problem isn't that Lena Khan and the FTC make a lot of rules, but that they unmake rules. They take down old rules and then cajole the industry in this direction or that. But both administrations do that. The Trump administration, the last Trump administration tried to do that on immigration policy and trade and other things. And so, and Congress can be very passive-aggressive too. They'll hold a hearing and bring in CEOs, tech CEOs, and they'll point their finger and criticize them and try to force them to change the way they do business. Not through new laws, but just through this sort of performative theater. And then we'll all be worn out and we'll start thinking about the next everything election. It'll be only 3 or 2 years away. Okay, everything I just described is totally familiar. It's so boring, they should have served coffee to keep people awake. But I think because it's become so familiar, we don't see exactly what it is that I just described. Let me describe something. Let me very quickly describe what I just described in slightly different terms. In civics classes, we learn that we have 3 branches of government. The high schoolers learn that you have a Congress that sort of looks out to the world, looks to the future, and decides what the rules should be, govern everybody going forward. And then you need, I'm told, a very energetic executive. You need an executive who acts in the here and now, looks to the law that's been passed, looks at the world at hand, and has to enforce the law while making any number of prudential judgments as to how to enforce the law in a given circumstance. And then eventually you have the courts who, as Tocqueville wrote, they don't enter the political arena with a bang, but they wait to be drawn in. They wait for the cases to come to them. They will hold hearings. They will decide the facts. They will decide the law. They'll decide the cases and issue their opinions. That's the civics, the schoolhouse rock version of constitutional government. When you look at government today, especially the first year of a new administration, I would suggest the best way to understand it is that each of the 3 branches of government has moved over 1 seat to the side. Our president now is mostly in the business of making the rules. The president comes to office, surveys the world around, looks to the future, and decides what rules should govern everybody going forward. This is itself, of course, a cliche. The president is now, his administration is now our legislator in chief. The main occupation or preoccupation of administration today is in making rules, less than enforcing rules that have been made for it. Then we go to the district courts, and this is maybe a little subtler. The lawyers definitely don't see it, but here's how I would suggest we should understand what the district courts do. When they burst into action with a bang, suddenly one judge in Texas or in Boston is asked the question of how these new rules should go into effect or not. And this judge makes sort of a preliminary reading of the law and then starts making all sorts of prudential judgments about who's hurt by the law, who would be hurt by the law not being in effect, how to enforce it in this given case. Our district judges are more and more the most energetic part of our government. In fact, I'd say they are now our energetic executives. They are moving very quickly in the here and now, making a mix of legal and prudential judgments about how best to administer our laws. And then, as I said, what's Congress doing? Well, they're holding hearings. If you look at a picture of sort of a painting of a scene from Congress in the 19th century, Henry Clay or John C. Calhoun, where are they? They're standing on the floor of the Senate, and they're talking to their colleagues. They're debating with their colleagues. What's the archetypical picture of a senator today? He's sitting on a bench alongside his colleagues. They're all sitting side by side. They're looking down at the person they're questioning. They're making judgments. They're saying, here's the facts. Here's how to understand the law. Here's who's right. Here's who's wrong. Congress, increasingly passive, increasingly waiting for things to be brought to it, almost exclusively reacting, sitting in judgment of what's happened so far, is in effect acting like judges. Definitely not legal judges. Maybe even a stretch to call them the Supreme Court of public opinion. But in their day-to-day work, they are doing the sorts of things that we would expect of a judge. Waiting, having matters brought to them, and then making findings. They even issue their opinions in their tweets or on Fox and Friends and on Morning Joe. We get their opinions. They don't really have cases or controversies, but they have a lot of opinions. So that's how this is the core point of my talk today, is that the best way to understand government misfunction today is that each branch of government is basically doing another branch's job, I don't mean it literally, but I mean it seriously. The president is our legislator-in-chief looking forward, our district judges, and all the way up now to the Supreme Court, which is asked to respond faster and faster, immediately to every controversy with a mix of prudential and legal judgments, are acting like energetic executives, and the Congress is acting like reactive judges. Now, the underlying cause of this, and here, if anybody's ever seen me talk before, they know I'm a one-trick pony on this. The underlying cause of this is delegation. Over the course of 100, 125 years, Congress has delegated more and more policymaking discretion to the executive branch. It didn't all happen at once. It wasn't intended from the start to be a total abdication of authority. It wasn't even intended at any given moment in time to be a total abdication of authority. But little by little, Congress, sometimes a lot by a lot, Congress delegated more and more discretion to the executive branch. And often when, especially conservatives and libertarians discuss this, we worry that the executive branch has become all-powerful. As was mentioned, I run a program called the Center for the Study of the Administrative State. Most of the time when conservatives criticize the administrative state, they criticize the magnitude of its power. And of course, it is immensely powerful. But that's only part of the truth. And I think actually the broader truth is more significant. It's not just that these delegations have empowered the executive branch. It's that these delegations deformed the executive branch, and I'd say each of the branches, into doing a very different job, one that it wasn't built for, and one that calls for very different virtues than the one the branch was originally created to embody. I won't recount that whole history here. I would just say if there was a turning point in the last 125 years, it would have been 1946, the year that Congress enacted the Administrative Procedure Act and the Legislative Reorganization Act. One, to reform the court's relationships to the executive branch. The other, to reform Congress's relationship to the executive branch, to actually, in the case of Congress, restructure, reorganize Congress itself to make it a better judge of what the executive branch was doing, but also in the case of the Administrative Procedure Act and the courts, calling on the courts to issue more and more decisions about whether an executive agency's decision was reasonable or not. Most of what the courts do vis-a-vis the administrative state is a judgment of reasonableness. The turning point was 1946, where Congress really ratified the executive branch's role as our new legislature. If there was a tipping point, it probably was 2014, January of 2014, when President Obama, having just lost control, his party having just lost control of Congress, said, I have a pen and I have a phone and I can use it. Of course, that had long been true, but I would argue that around 2014, it was the moment that we saw the biggest shift towards unilateral policymaking in the form of the net neutrality rules, the Clean Power Plan, immigration policy, environmental and energy policy more broadly, an approach to presidential lawmaking that President Trump only further embraced and encouraged, and the same with President Biden and whoever comes next, President Trump or President Harris. But the turning point was President Obama's pen and phone moment. Now, this shift of power and discretion to each of the branches, changing the branches, it creates at least two mismatches. One is a mismatch of powers, and one is a mismatch of virtues. Let me start with the mismatch of powers. Yes, the president's our legislator, the courts are our executive, and Congress is our judges. Congressmen are our judges. But they don't actually have the powers to do those things the right way. The president and his administration makes any number of rules and regulations, sometimes just an executive order that the president signs, sometimes a long 200-page rulemaking out of the Department of Commerce or whatever. They look like the U.S. Code. They're in the Code of Federal Regulation. But of course, they aren't really final, and they don't have the same kind of inertia and weight that an actual law of Congress can have. So a president can make a lot of rules in his or her administration, but then the next president will make all the new rules. Hamilton predicted this in Federalist 81 or 82, right? That each new president would show his merit for the office by immediately wiping away whatever his predecessor did. We have that today, and it's unavoidable, even at a moment now where administrations and the agencies in the Biden administration speak of Trump-proofing a policy. It's impossible, of course. A president can really only make rules for his or her administration, and maybe for a year or two afterwards. The president just doesn't have the same power as Congress does to make law that stays law and is treated as law. The judges are our new administrators, but they only have a negative. It's almost impossible for judges to force an administration to carry out a policy that it doesn't want to. You can't really push on a string. So judges administer, but only in a negative. They can only strike down or block what's being done. They can't carry things out into further administration. Although that may be proved to be wrong. In the last administration, when Republican state attorney generals went to Texas to block the FDA's approval of mifepristone, the abortion pill, a group of Democratic attorneys general went to, I think, Washington state and filed a lawsuit to force the Biden administration to continue to carry out that policy. But on the whole, judges have only a negative power, not a positive power. And so they administer, but only halfway. In Congress, they sit in judgment, but unlike actual judges, they can't really resolve anything, because the cases never end, the controversies never end. They issue, these judges are members of Congress, they issue opinions, but they'll issue more opinions the next day and the next. They're a judge sitting over a case where the case never ends. I used to say people ask, what do I miss about being a lawyer? I say, well, I miss that the conversations end. And sometimes you'll win a case, sometimes you'll lose a case, sometimes you'll settle a case. And the judge might get it wrong, but at least it's over and you can move on to the next case. In the court of public opinion, we never can really move on to the next case. Congress sits in judgment, but its judgments don't mean much at all. This mismatch of powers, I think, is exemplified by what I mentioned earlier, the fact that more and more both the executive branch and Congress act most powerfully when they're passive-aggressive, not by making things that actually stand the test of time, but unmaking things, unsettling things, and hoping that all of us who are unsettled will move one way or the other in our activity, not because Congress passed a law, not because the administration brought an enforcement case against us and won, but because to contest the executive branch or the legislative branch is too much of a hassle. And so it's not worth the trouble. And so more and more is done passive-aggressively. It's not exactly the ideal way to run a country, but it is in some ways the legislature's and executive branch's strongest tools for the job they're trying to do now, the president making the rules and Congress deciding the cases. So that's the mismatch of powers. More important, I'd say, is the mismatch of virtues. When I was here a couple of years ago discussing administration and the Roberts Court, I was discussing a lot, I focused a lot of my remarks on the virtues of good administration, of energy, of steadiness, and the ways in which the Roberts Court seemed to be gravitating towards Hamilton's wisdom of what the virtues needed for good administration are. When we look at the virtues that are needed by the three branches now, it's not exactly Hamiltonian, we'll say. The president to make rules, whether through executive orders, which even though they're signed in the blink of an eye, they take months oftentimes to write, or these rules that come out of agencies that take many months to write. They're slow. They are slower than a president would naturally want to be. It's a lot of deliberation, months and months of drafting and redrafting, a lot of conversation, and in terms of at least the regulations, a lot of transparency. The agencies have to go through notice and comment oftentimes. They have to open up their policies to the country and take all sorts of suggestions, a gigantic suggestion box that the president or at least his proxies have to sit through and look through. Administration today is slow, it's transparent, and it's unsteady, with each administration flip-flopping from one to the next. Administration today, being mostly not executive but legislative, is Hamilton's nightmare in terms of the virtues and their connection to the office. What about the judges? What are they doing? Well, these cases come to them very quickly. They have to act fast. They have to act and not just react. these things happen so quickly that oftentimes when a judge issues an initial decision, they don't even write an opinion. When the court decides whether to grant a case or decides whether to issue an injunction, the Supreme Court even, they usually don't have a written opinion. That will come later at the end of the litigation. But the things that the courts do at the front end, which are increasingly the most prominent and most controversial things the courts do, there's no written opinions. The judges are acting quickly and they're acting secretly. Great for an executive, not necessarily great for a judge as we originally saw them. And Congress, what are they doing? Well, they're passive. More than that, they're I wouldn't say members of Congress are too principled, but too principled in a way. When they are having their hearings and they're issuing their opinions, these judges, these members of Congress, they're pretty absolutist. Somebody is right and somebody's wrong. I know the principle and you are violating it. I know the fact and you're on the wrong side of it. There's no need to compromise when you're this kind of judge. You're not trying to negotiate on legislation or anything. You're just making your opinions known. And so for that, it's less about compromise, deliberation, and moderation. It's about fortitude. Saying the right thing, being principled. Hamilton said that judges would need an unnatural degree of fortitude. And in some way, at least this particular way, our members of Congress have a very strong degree of fortitude. You're not going to get Senator Ted Cruz to change his mind on this. You're not going to get Senator Elizabeth Warren to change her mind on this. They're very, very principled all the way down.
How about Elise Stefanik?
See, I have an asterisk next to principled. I would say they're principled within any one administration. And then after the everything election, sometimes the principles change a bit. So we have this mismatch of powers that leaves government eventually sort of inert. We have this mismatch of virtues that wears us all out. Where does that leave us, the people? Well, it leaves us demoralized. We have a democracy that is demoralized now because even 2 years after the everything election, very little will have changed, and we'll go back to arguing about everything, waiting for the next everything election. To some, this is a lot of fun. You can see them on cable news. For the rest of us, it's pretty exhausting. I think it leaves us demoralized in both senses of the word. And I'll say a little bit about that later. But first of all, just to focus on the people's politics. This mismatch of virtues and of powers in government distorts, deforms the people's approach to each branch of government. We now criticize judges as if they were politicians, and we've done that for a long time, but now more than ever, as soon as a judge says anything, does anything, the first thing you'll find about in the news story is which president appointed them, which political party are they. We judge our judges as if they were elected officials. For Congress, we judge them on how principled they are, their unwillingness to negotiate rather than their willingness to negotiate. And we judge our presidents, as we are for the next few days, a little bit more, on whether they have the right, mostly whether they have the right policies, the right rules. Not exclusively, we'll get back to that in a moment. But we're very, very interested in the president's sense of what the right rule is, rather than how he would go about enforcing the rules that were already made. But I think this demoralizes the people in terms of our own virtue in at least two ways. One, in a world where every election is the everything election and all policies are up for grabs every 4 years, everything changes, you don't have much of a rule of law. And that reduces all of us who live under these ever-changing rules, to, if not go back to a state of nature, at least look over our shoulders a little bit more often and have to think, well, I know what the rule is today, but that's not going to be the rule 4 years from now, 5 years from now, or it might not be. So what's the real rules? What's the rules that will actually govern me, rather than the rules on the page? We have much less respect for a rule of law because we have much less respect for the rules that purport to be law now. So we, as law abiders, are more cynical, more strategic. I often say the most bearish sign for American rule of law and our economy today is the fact that the consulting firms that were created 30 years ago to study emerging markets and third world countries, is it safe to invest in the newly freed Eastern European states? Is it safe to invest in South America? Things like the Eurasia Group, they now have departments that study U.S. politics. It's for political risk, as if we're a third world country that really might not be investment grade. But also, I think the people's morals are deformed vis-a-vis our presidential elections. When the presidential election is the everything election, and our presidents will make all the new rules, the people are confronted constantly with the question of, well, will this president make the right rules? What will those rules be? And we think about what these candidates say, but because we can't judge them just on what they say, we have to guess what kind of rules will they make in their executive orders and their regulations. We spend a lot of time looking for clues in their temperaments, clues in what they say, reading between the lines of what they say. We have to constantly focus on not just the rules, but the president's attitude towards rule itself. And of course, we'd have to do that for a president who is an actual executive. But for a president who is our sole lawmaker, suddenly the stakes are enormously higher. We have to spend a lot more time reading things into what a president does or doesn't say, their attitude about who's their friend, who's their foe, what kind of law will they make on the fly. And so these things being totally incomprehensible, trying to predict what all the rules will be and what all of the attitudes of the rule maker will be, we become demoralized and suspicious. So I'll say a word about reform. We live in an era of reform, and so far the reforms are mostly bad. I've spent some time working on some of these issues. But I'd say it's interesting that at least some of the reforms coming from my friends on the left right now, it's interesting to see that they're focused on the structure of government. They're focused on how we select select people for government. What's their tenure in office, and how do we remove them? The obvious example is the Electoral College. We'll be having an argument about this soon, I'm sure. How do we elect a president? Why do small states get a disproportionate voice? Do they have too much of a voice? Why doesn't the person who wins the national popular vote just become the president? That's just, isn't it? Well, it is, in a sense, just if the president's job is to make all the rules. There's a reason why we don't have an electoral college for our House of Representatives. Our House of Representatives is directly elected because they are our main they were our main representatives, our main lawmaking body. And so to the extent that the president is our main lawmaking body, I suppose it makes sense to have him or her directly and popularly elected. It might make sense to let him or her be elected and reelected forever. We don't have term limits for members of Congress. The subtler example might be the debate that I'm more directly familiar with and involved with, Supreme Court term limits. It was mentioned I served on President Biden's Supreme Court commission a few years ago. Who doesn't love a group project? We spent a lot of time reflecting on how many justices should be on the court. Should they have life tenure anymore? Now the debate, including the debate that President Biden himself has been pushing the last few months, has been to put term limits on justices. They should serve for 18 years. There should be a new justice appointed every 2 years so that every president, every 4-year term gets 2 Supreme Court appointments. I've been debating that particular set of issues ad nauseum for the last couple of months, so I won't bore you with the details, but I'll just make one observation. When Democrats argue that a Supreme Court justice should serve in office for a long time, should be independent, but not completely independent. There should be some rotation in office. These judges aren't kings. I have not seen a Democrat yet realize that what they're doing is replicating the original debate for the president's term of offices. We want a president to be independent, but not too independent. We want them to serve for a few years, but not forever. We want them to be accountable, but not too accountable. The call for Supreme Court term limits is a bad idea, but it's a revealing idea for what it tells us of people's sense of what it is that judges are actually doing around here. If they are our new executives, our new administrators, well, it would make sense that they should serve a term of years like our actual executive does. Maybe there's better reforms, and I'm almost done. For better reforms, I'd suggest two categories. One is, how can the court and Congress make the executive a better executive? And the other is, how can the court and Congress make themselves a better version of themselves? The court, it seems to me, the Roberts Court is currently in the business of trying to make the executive branch look more like an executive. They've taken away the executive branch's discretion somewhat by getting rid of Chevron deference. They've issued other decisions making it more difficult for presidents to flip-flop policies. If you're interested in this, there's a great PCG video by me from about 2 years ago. You too can be viewer 335 of that video. But the best way to understand what the Roberts Court is doing with administrative law is trying to make the president a less effective legislator and a more effective administrator in some ways. And Congress could do that too. The proposals that they have for taking away some powers that were delegated to the president might make the president a more effective administrator. But in some ways, I'm more interested in what the courts and Congress might do to reform themselves, to make themselves a better version of themselves. I said this in my closing statement at the end of my time on the Court Packing Commission, as it was so lovingly called, that some of the challenges for the court right now are to understand its own role in this time and political moment. To maybe learn how to move a little bit faster, but not nearly as fast as it's currently moving. To learn how to exercise discretion, but less discretion in terms of how it picks its own cases, how it decides when to issue injunctions or not. Right now, I think the courts need to think very hard about how to make themselves more court-like again. And the same with Congress. And for this, I'm lucky to work at AEI, where there are smart folks like Yuval Levin and Phil Wallach and Kevin Kosar, who every day are thinking about how Congress could become a better version of itself, mostly by taking power away from the leadership of Congress and not sending it all the way down to individual members, but concentrating it in committees where Congress actually, not in its oversight hearings, but in the not too long forgotten legislative process, can actually go about the work of legislating. And then, of course, my friends at AEI, Ben and Jenna Story, would say, don't forget civic education, that we do need the people to learn or relearn how our government was intended to work. But of course, as Tocqueville adds, this is best done not through words, but through experience. And that the more we could devolve to states and local organizations to just relearn the work of government might have good ramifications for the people's sense of their national government. But for me, I think what the moment calls for is a replication of what we saw about 50 years ago. We're coming up on the 250th anniversary of 1776, the 50th anniversary of 1976. After the bicentennial, we saw a flourishing of attention to the founders that created what we now think of as originalism. With Irving Kristol and Martin Diamond and others, 50 years ago, writing about the founders, speaking about the founders in a way that had been long forgotten, it inspired a generation of lawyers to think about the law and the founders. And it's not a coincidence that originalism rose it's surely not a coincidence that originalism arose just a few years after the bicentennial, where we started to think again about the founders and their sense of law and their sense of the role of a judge. And in many ways, the greatest conservative victory of the last 50 years is conservative lawyers and judges relearning the wisdom of the Federalist with respect to the meaning of law and the role of the courts. Now is probably the time to relearn the other half of the Federalist, the other third of the Federalist, the part that wasn't about the auxiliary precautions, but the original precautions, the people's virtue, the virtue that's expected of each part of government, which of course varies from each part of government. What's virtuous in a president is different from what's virtuous in a congressman, different from what's virtuous in a judge. And we've lost that vocabulary. We used to say, that's not very presidential, or that's not very judicious. We've lost that vocabulary, and if there's one thing we could relearn as we return to the founders for the 250th anniversary, it would be relearning a vocabulary of Republican virtue, both among the people themselves and in each part of government. It would be unvirtuous of me to go on any longer, so maybe I'll stop there.
Okay.
Otherwise, we always invite you.
Thank you. Thank you so much, Adam. That was great. And we have two professors of American politics in our company today, but the rest of us are free to chime in as well. So let me, there's a definite non-professor over there, Tom Palmer.
If either candidate got both houses with them, along with them, would yours, that first third of your remarks about not much happening in the near future be the same?
Mostly the same, actually. More the same than you would expect. There would be a big spending bill. There might be some new legislation. We'll see. A lot would hinge, I suppose, on if President Harris and a Democratic Congress abolish the filibuster, and then maybe first around a Roe v. Wade bill, followed by laws on voting and a restructuring of the court and other sort of pent-up legislative agenda items. But barring that particular circumstance, President Harris and a Democratic Congress willing to get rid of the filibuster, no, I think mostly the policy-making energy will remain in the president's hands. As Hamilton wrote a few years after the Federalist, the president has a unique power to create an antecedent state of things, and that hasn't changed. So whether or not the Congress wants to legislate, the new president will immediately create a new baseline through executive orders and other things. And that, as we've seen for the last decade or decades, immediately drains the policy-making energy out of Congress. I don't expect that to be all that different, even if President Trump has a Republican Congress or President Harris has a Democratic Congress with a filibuster.
Paul Peterson.
So you have a very interesting talk, and there's lots of issues to think about, but I thought the deciding moments that you identified, I thought of some others, and it's very difficult to decide what's key. But it seems to me the Supreme Court decision, I can't even remember the name of it, back in the 1930s, where an executive order was given the same standing as a law of Congress. Before that, it was unclear whether or not an executive order really had the full force of law in the same way that a law of Congress has, and we don't see very many. If you look at the data on significant, and I don't mean mine, sort of. There's going to be every September 19th is going to be some chicken day or something like that. Forget about nothing kinds of executive orders, but significant ones. There's not very many before the 1930s. But after that Supreme Court decision, you get the growth of executive orders. I just looked at executive orders for my class on Monday, and there's been, executive orders ever since. I mean, Roosevelt begins to do it a lot. Truman did it a lot. It's just continued with every president since. So it's not like there's been, it doesn't begin with Obama, and it doesn't grow with Obama. If you look at the raw numbers now. The significance of the orders could have been increased and all of that, I admit. But I think the really decisive moment comes in the 30s. And the second thing that I think happens is the nuclear option. That's the Harry Reid's decision to allow cloture to be imposed on executive and judicial appointments other than for the Supreme Court by majority vote. So all of a sudden, you're able to place, assuming that you can get control of the Senate, all you need is 50 plus the vice president, which could happen again. Either party could be in that place after this election, and you can then put all your cronies right there, and you can see that we have, ever since that nuclear option, it's become possible. Trump could not have stacked the executive the way he did had Harry not given him permission. And the same is true of Biden. They're operating a different kind of administrative state than existed previously. So that was my first and largest reaction to what you said. Did you get the dates right?
Thanks, Paul. I'd say with respect to the nuclear option, in particular judicial appointments, I think you're absolutely right. And my friend Sarah Isgur, a writer at the Dispatch, she's pointed this out, that until that so long as judicial nominees were subject to a filibuster, and even before that, in the pre-judicial filibuster era, where the judicial politics were just different, the best way to become a federal judge was first to know a senator, and second, to not have a paper trail. When I was studying law a few blocks from here, a long time ago, it was well known that if you wanted to be a judge someday, you better not publish anything anywhere. No paper trail. Now you could never become a judge without a paper trail. Now you need a lot of receipts. You need the president to trust that he knows what you're going to be like. The public, the senators want to know. And since the judicial filibuster ended, you've seen now that the judges have a long paper trail. They speak a lot, or they even tweet a lot before they're judges. And the easiest way to not become a judge would not be to have a paper trail. And so the nuclear option, it was a huge turning point. You're going to say something?
Or any kind of trail.
Yeah.
In all the years that we've had the PCG, there's only one speaker who's refused to be recorded, and that was Stephen J. Breyer. Later became a Supreme Court justice.
So we have you to thank.
Yeah.
Yeah, he was a good judge. One other thing, though, when I was sketching this out, I was hesitant to I was hesitant to include a turning point because, and I might take that back, because it's best to think of this as an accumulation of small things over time. Oftentimes my friends who focus on Congress say, Madison would be so disappointed. He said ambition must be made to counteract ambition, and the interests of the man must be attached to the rights of the place. But now members of Congress just want to talk. And I said, well, no, they only want to have oversight hearings. I said, well, yes, but that doesn't disprove Madison. Every time Congress would delegate more discretion to the executive branch, it created both more need and more opportunity for oversight, right? Congress had more reason to hold oversight hearings, and they would get more political bang for the buck out of oversight hearings. And just little by little, with every delegation, the amount of political benefit from oversight would outweigh the political benefit of legislation. So now today, even at Congress, the interests of the man very much are attached to the rights of the place. The rights of the place are now primarily rights of oversight and publicity. And that is itself a function of Congress having delegated power to the executive branch. Congress was uniquely positioned to change its own incentives, whether it knew it or not, at the same time that it changed the incentives for the other branches of government.
Was this a choice, or was it inevitable? So I think political scientists make proofs which render things inevitable.
My friend Adrian, my friend Adrian Vermeulen says that it was inevitable, and if we erased the administrative state tomorrow, it would come back like a zombie. Although he wouldn't say that. I don't know if it's inevitable or not. Actually, I know that there's a lot of path dependence, and I suppose whether it's inevitable depends on where we stepped on the path.
Well, people use the word complexity.
Yeah.
To characterize our situation and distinguish it from simple days back in the founding days.
Speaking of simple days, that reminds me, as an Iowan, I'd be very much in favor of National Chicken Day, I want to say. But to your point, I breezed past the delegation part of the talk because that's what I talk about most of the time. But I think it would be a mistake to suggest that these delegations happened for no reason or for only bad reasons. That at any given moment in time, there were reasonable reasons for delegating discretion. First and foremost, the fact is, as Madison wrote, all laws are going to be somewhat vague until they can be liquidated through adjudications and discussions. And there's only so much Congress can do to make law so specific. Maybe Congress could have tried harder, but every legislation is always going to carry with it some kind of delegation of discretion. And we need to take seriously the fact that technology now causes issues that would be the subject of legislation to become much more complicated and to move much more quickly So it's understandable that we would want the part of government that can move the fastest to have more responsibility. And also, I'd say in some ways, what we see today is the result of James Madison being proved correct in Federalist 10. We have a country that over time knitted itself together more closely, both in terms of our economy, our culture, our communications. If Federalist 10 pointed us towards an inevitable future of a country that's one country that can move quickly both on the ground and in our communication, then I suppose a lot of what we see is somewhat inevitable.
So I don't think then the delegation issue, that may have been inevitable. What's not inevitable is that the executive branch will be very distinct from the legislative branch. So if the legislative branch is going to be representative of the diversity and the interests in the society, it's going to be very difficult to get a majority. You've got to work towards consensus. You've got to have a negotiation between the Senate and the House. So the process has to go on before you get the law. It takes all two years to get a law. So now the executive can move much more quickly. And once you get an executive that can be packed with the partisans, so you have what Madison tiered, you have majoritarian rule because you no longer have the cloture. If we get say we can get rid of the electoral college or so that you have a faction which is not a majority is able to capture the power of the presidency or a bare majority, they can then move the system very dramatically and pretty much ignore Congress in the process. So it's the fact that the two branches of government have a different political base.
Well, I will say, and I'll add to that, when I pointed to 1946, the Legislative Reorganization Act, Administrative Procedure Act, as being a turning point, and I think in hindsight a mistake, in that it ratified and really made concrete the shift of the roles of Congress and the judicial branch vis-a-vis the executive branch. I think we should worry about reforms that would have the same effect here. That's why I'm so worried about getting rid of the Electoral College, making it more a populist, popular election suitable for a House of Representatives, or changing how we appoint or remove judges in order to not only decrease their independence, but knit them more closely to the executive branch. I think we're replicating the mistakes of making these shifts in just the pace and structure and temperament of our government concrete. If we've learned one lesson since 1946 or since 1789, it's that from time to time we need correctives to maybe limit that inevitability of acceleration. Maybe, and this is probably this popped into my head, so it's probably wrong, but maybe there's a cultural contradiction of constitutionalism, that our Constitution points us towards a faster and more unified government that ends up undoing the culture that sustains the Constitution. Well, then our constitutional and quasi-constitutional reforms ought to be in the spirit of slowing down that pace of change and nudging us back towards the better Constitution. But that might be wrong.
Go ahead, you do.
Thanks, Antonin. I think it's a really useful lens.
This is Shep Malnick.
Really useful lens for looking at a lot of things. So it was great. And when you were talking about the courts, I thought one of the advantages of your discussion was it took attention away just from the Supreme Court and looked at these really big changes of the rest of the judiciary. And just for, Adam knows as well, but it's pointing out one of the things happened is you have these very active Republican and Democratic attorneys general who are bringing suits on virtually everything. And they have their favorite courts. And one of the consequences of this is you're getting different decisions, different districts with often nationwide significance. And then the consequence of that, many of those cases go to the Supreme Court, but they're supposed to do it quickly. And they're supposed to decide very important things, and now they do that often without an opinion, without argument, and that's now become known as the shadow docket.
Yeah.
And there's a lot of concern about this, but it's not at all clear to me what you do about it. So if you've got these activist courts, and you've got so many of them, You're on the Supreme Court Commission. What do you do about that?
Well, I'm glad you brought that up. Let me offer you an example from my now home of Virginia. Barely a week ago, maybe 2 weeks ago, the Biden administration's Justice Department brought a lawsuit against the state of Virginia to prevent Virginia from purging its voter rolls of voters who were in the system as non-citizens. That case couldn't have been filed more than 2 weeks ago. Fact check me, it was probably 3 or 4 weeks ago, but it feels like it was just yesterday. Within a week or two, a district judge issued an opinion, a preliminary injunction saying Virginia can't do this. It raced through the Court of Appeals, and just in the last 2 or 3 days, the Supreme Court issued a preliminary decision blocking the district court from blocking Virginia from purging the voter rolls. There's no opinion. It's, in theory, this case would play out over now a few months. There'd be a final decision eventually. But it's just as you described. Its technical term is not the shadow docket, but the emergency docket at the Supreme Court. But everything seems to be an emergency these days because everything races up to the Supreme Court for a preliminary ruling. And when I was to your point, Shep, when I was on the Supreme Court Commission, we were, the name suggests, we were focused on the Supreme Court. And is it exercising too much discretion when it issues these injunctions? Is it not explaining enough? All sorts of things. And I kept trying to focus my colleagues and the public on the fact that this is not just a Supreme Court issue. This is all federal courts are moving much more quickly, deciding much more at the front end of a case, and deciding much more without written opinions. It's the opposite of what you'd expect out of a court. And the Supreme Court is doing it because the lower courts are moving faster. And the lower courts are moving faster because the administrative state moves fast. And it's that acceleration of the pace of government that makes the courts move faster. That's 2 degrees downstream from my delegation issue, but that's exactly how we get there. It's not just about changing the procedures in the Supreme Court or the procedures in the lower courts, although there's discussion of that. I do think it requires not just studying the federal rules of civil procedure, but also reading Tocqueville and his description of what a good judge is, and the virtues of judges waiting for a case to find them, deliberating and issuing a ruling. Our judges are now the opposite of that.
What do you think of the recommendation that the judges in the district courts should only be able to do this emergency thing for their particular jurisdiction and not nationwide? People have proposed that as that solution to the issue that you're.
I don't know yet, Paul, and to be fair, when I was a lawyer, I was in the nationwide injunction business from time to time myself. So either I have sympathy for it or familiarity bred contempt, I'm not sure. On the one hand, it's crazy that one district judge who can basically be cherry-picked, or a small handful of judges who can be cherry-picked by the litigants, knowing how the judge almost certainly will rule at the outset. It's crazy to allow that person to become our national magistrate for the moment. On the other hand, if a judge, if we get 50 judges or 200 judges, each issuing different rulings in their individual districts, and suddenly we look at a map of how a new policy is going into effect, and it almost looks like an election map. You see the red districts and the blue districts, and here the law means A, and here the law means B, and it's all these intermixed little blue and red dots on a map. That's no way to run a country either. So I don't know the answer to your question yet.
Let me just bring this home for a second and talk about the red and blue and district court power. The Title IX regulations were enjoined in 26 states. But also, I mean, that does not include Massachusetts, but does include Harvard and Boston College and many colleges around here, because it applied to all of the colleges in which the Young Americans for Freedom and Mums for Liberty had people in college. So it's a crazy quilt result.
Quickness is a sign of, or gives fuel to, impulsiveness, which is a sign of ever more democracy. I'm wondering whether ever more democracy isn't the general motive which is responsible for all 3 changes. that you want to do something more democratically, therefore more quickly, and without regard so much to the question of whether democracy works well, but with simple regard to whether it is more, to use a distinction of Aristotle, more demotic versus democratic. Demotic meaning just simply more populist.
I appreciate the translation at the end.
Yeah.
It's a funny kind of democracy that gets Congress out of the business of legislating, but I think your point is basically correct. At least we'll begin with the executive branch, that the fastest kind of democracy would be one in which there's a single democratically elected lawmaker, and he makes the rules for everybody. He can do it very quickly. That is a faster kind of majoritarian democracy, not much of a deliberative democracy, but it is a democracy of a sort. I wouldn't say that the judges in acting more quickly are self-consciously trying to be more democratic. I think it is more the gravitational pull of institutional incentives and just the needs of the moment. The fact is that when Congress delegates broad discretion to a president and his agencies, it's unavoidable that judges will have to make mostly questions of reasonableness. How quickly can we reasonably intervene in a case? Or what's the reasonable decision? Is this reading of a statute reasonable or not? Was the agency's factual findings reasonable or not? And I suppose reasonableness is a kind of democratic value too, but I don't know that the judges are themselves self-consciously democratic in this sense. Although more and more judges, I think, style themselves as men or women of the people, and that would be democratic as well.
To the extent their virtue is empathy,
Yeah.
they're in that way more democratic.
Yeah, and I want to say, by the way, when I criticize the judges for being in the business of reasonableness, as with everything I'm describing here, I don't want to make the mistake of suggesting that they're completely wrong to be doing it this way. A close reading of Federalist 78 reminds us that the hardest questions a judge would have to make in our system is between a fair and an unfair construction of a statute, between a reasonable and unreasonable reconciliation of a statute and the Constitution. I think in some ways, there's a tendency among lawyers to underplay the reasonableness judgments that Hamilton had in mind. But now the reasonableness judgments are, as much as anything, reasonableness in the pace of judicial decision. And that's much less Hamiltonian.
Yes, Tom.
So Clarence Thomas and Paul and I are all worried about judges in Honolulu making nationwide decisions, and the Times does a lot of bad things, but today they did do a blue and red map of judges and who appointed them. It's quite instructive.
Who wrote the piece?
All the districts.
Who wrote the piece?
Matthias Schwartz and June Kim. Obviously, it's a
It really is the map I just described, huh? It's,
and of course, it's a warning that Trump might be elected and make more red on here. But how would what Paul suggested even be done? Is there even a mechanism for saying that a judge in California can't make a decision that everybody has to agree with until somebody overrules him?
You know, I don't know how it can be done, but here's my suggestion for how it might be done. I wrote about this a few years ago. Because like I said, I'm of two minds of whether nationwide injunctions are inherently good or, I mean, they're not inherently good, but are they completely bad? Is there a place for them or not? The problem really seems to be the combination of the power of one judge to make a nationwide injunction and the power of the plaintiffs to pick who that judge will be. It's that combination that creates a real problem. And so I suggested once a few years ago, there ought to be a lottery. That if you want to sue the government and get a nationwide injunction, you can do that. That won't change. But when you go to court, you file your case in the Northern District of Texas or the Northern District of California, and in your case you say to the judge, please enjoin this nationwide, well then your case should immediately go into a lottery. And it'll get spit out. They could even do it on TV. The number comes out. And the Powerball says you're going to hear your case in the Western District of Wisconsin or something. Southern District of Wisconsin. So you can pick your nation, you can ask for a nationwide injunction. You just can't pick your judge. And you might want to be in Texas, but you'll wind up in California or Oregon. And you might not like your nationwide injunction so much then. And you might not like the kind of sanctions that the judge would give you if he or she thought your case was unreasonable.
But then you could drop the case.
You could drop the case? Maybe you should be allowed, you should have some skin in the game. But that's the kind of reform I'd suggest.
How was that received?
Oh, I'm sure all 45 people who read that blog post thought it was brilliant, actually. But, yeah.
Avi Nelson.
What do you have to say about the Ginny Thomas problem?
There's a Ginny Thomas problem?
No problem. Short answer.
I'm sorry that all my answers to your questions begin with I'm of two minds of this. On the one hand, Mrs. Thomas is entitled to have her own career and her own life. I think it's a little strange to see so many progressives today complaining that Justice Thomas doesn't do enough to shut up his wife. I find that very strange.
And yet there is a disproportionate impact
Yes, there is.
on the nation as a whole and on the court because of how she's behaved, what she has said, what she has done.
There very much is. I keep coming back to Hamilton, but I always do. Federal 78 makes clear that judicial legitimacy rests on how the judges go about their work and how the people see their work. And those two things are both related, but not completely. And so it's important for the court and the justices to really think seriously about how their work is seen. And I think it's a huge problem, to say the least, to see that one Supreme Court justice, and in many ways one of the best justices, and certainly one of the most prominent ones, is that his wife's career is in partisan politics and at the hardest edge of our partisan politics.
I mean, is it possible to consider a possibility that one of the things that you accept if you are going to be appointed to the Supreme Court is that your spouse has to stay out of it? It's sort of akin to that you have to put your assets in a blind trust so that you can't manipulate them. But I realize it sounds like an extreme proposition, and yet what's happened with Ginny Thomas, at least from my point of view, a non-lawyer, is unprecedented and has caused a sort of a ripple effect, a dislocation effect that is really disproportionate to what's going on, and I think quite dangerous. I think it's undercut Clarence Thomas, and I think it, to some extent, undercut the court.
Yeah, I would agree that it's undercut Justice Thomas and the court. I stop short of trying to prescribe a rule here because I just don't know. We have recusal requirements, and the justices, they should recuse when they have a real personal stake in a case. And that's very, very easy to define when it's a judge's stock holdings or something like that, or a family member works for a party to the case. It's much more nebulous when, say, Mrs. Thomas is not the party to any of these cases. To the extent that she's even a party to the events of some of the cases is a subject of dispute. How involved really is Mrs. Thomas in, say, what happened on January 6th, and to what extent was she sending text messages to a White House chief of staff who was just kind of disregarding them? We don't know. But when every presidential election is the everything election, and the presidential politics is everything politics, it's that in that context in particular, extremely difficult to separate Mrs. Thomas and her activism from within presidential politics and national politics from the work of the court. I think that the calls for recusal to Justice Thomas have all been overstated, and even more so in the case of Justice Alito. But I think that Mrs. Thomas's political vocation certainly casts a light on Justice Thomas's work that I think makes Justice Thomas's work harder, and it makes for a broad segment of the people, makes it harder for them to trust that Justice Thomas is acting like a neutral judge.
Yeah, and in that regard, it damages the court, which until recently was one of those bodies that had retained, should we say, respect amongst the populace as a whole, and now that's been compromised. Now, somebody said one of the things you learn in law school, which I never went to, is that hard cases make for bad laws.
Yeah.
And this may be such a case. I don't know, maybe the answer is you just have to live with it and hope it doesn't happen too often, but there's real damage here.
I wish Mrs. Thomas would retire from politics, and to say the least, and I wish, and to the extent that, and so long as she doesn't retire from politics, it makes it only more difficult for Justice Thomas to avoid the political accusations that have always dogged him, but dog him now more than ever.
Can I change the topic slightly? Because there was another thing I wanted to bring up, which you haven't mentioned, that I think you need to think about, and that is the national government is not the only government we have in the United States.
Mm-hmm.
We have state and local governments, and they do a lot. And while all of this is going on that you're describing and accurately describing, and it's fascinating material, you have this huge system. You've got the state courts, which are massively important, and you have the governors and you have the state legislatures, and they're doing a lot of work out there. So there's a lot of stability in the system, even though there is this dynamism at the top, which can be unsettling. So yeah, there's a lot of stability in the system that you're not really taking into account.
Yeah, the point's well taken, and far be it from me to understate the role of state Supreme Court justices, including Justice Mansfield in the great state of Iowa. But Paul, it's worse than you think, because even in the states, more and more of what state government does is as an administrator of federal policy, either the spender of the recipient and spender of federal funds, or the administrator of federal programs ranging from education, well, as you know better than anybody on education, but also on the environment, on energy, on any number of issues. The states increasingly act and see themselves as acting as agents, as branch offices of the federal government, and more specifically, federal administration.
I have a nerdy question. Talking about what we do about district court judges, why not simply centralize review of all rules and regulations in the DC Circuit?
Yeah, I would counsel on the opposite. I think that for a long time, the DC Circuit's predominant role in reviewing regulatory issues has, I think, made administrative law, it's worse in administrative law. You don't get nearly as many judges weighing in on these regulatory issues. I think in some ways administrative law has improved in the last 10 years because you're getting more cases in the Fifth Circuit or the Sixth Circuit or elsewhere. And so I'd say I would, if anything, go in the other direction. I would want more federal courts hearing these issues to get a diversity of opinions. I had another thought in there, and now I've lost it. There's another reason, I'm sure, for it's that concentrating all this in the D.C. Circuit makes D.C. Circuit judicial politics as bad as about anywhere other than the Supreme Court. The politics of appointing judges. It's not a surprise that after the Supreme Court, it was the D.C. Circuit where you saw the first real knockdown dragouts over judicial appointments. John Roberts not getting a hearing at the end of the first Bush administration. Elena Kagan not getting a hearing at the end of the Clinton administration. The filibuster of Miguel Estrada, the filibuster of Brett Kavanaugh. In fact, I believe the nuclear option was done by Harry Reid so that they could appoint maybe 3 more judges to the D.C. Circuit in particular. So if anything, I would want to spread it around more than it currently is.
Do you have a sense of which party would be more inclined to provide these, as you say, needed limitations of this possibly inevitable speeding up and shifting of powers and virtues? And I would like you to talk more about concrete reforms and how how they would be addressed, who would be lobbied, and who would actually have an interest in the current political landscape to enact some of them?
Well, I would say conservatives, but that's probably because I spend most of my time around my friends. But I mean, as a matter of fact, what the Roberts Court is doing from the judicial side is the kind of thing I was hoping that they would do in terms of slowing the pace of change from one administration to the next, which, to be sure, is slowing things down, and that's not great for administration. But so long as the administration is our legislator, I would want it to be slower and more deliberate. So the Roberts Court's done a great job of that, and not just in the Chevron deference cases. When I was here last time, I talked about the Trump-era cases, where the Supreme Court ruled against the Trump administration when it tried to add the citizenship question to the census, or when it tried to repeal the DACA immigration policies. In each of those cases, the court did not say that the administration couldn't do those things. It said it did them too quickly, either with too little analysis or too little honesty in its analysis. So across administrations, the court, I think, has taken good steps to slow down the pace of change in administration. Likewise, in Congress, some of the best calls for congressional reform of the kind that we at AEI have been the sorts of things that, until recently, Congressman Mike Gallagher and others were calling for a return of power to the committees. In the case of congressional reform, it might be accidental as much as anything. Republican members of Congress seem to distrust their leadership in Congress more than the Democrats do right now. And so if one party in Congress is more likely to decentralize power out of the leader's office and down into committees, I suppose it's more likely to be Republicans doing that to Speaker Johnson than Democrats doing that to Speaker Jeffries, perhaps after the next election. But I don't know yet. I don't know yet. In terms of concrete reforms in Congress, the best thing Congress could do for itself would be to bulk up its own staff and reverse the well-intentioned but ultimately mistaken reforms of the 90s, taking away Congress's budget, taking away its own internal support, the internal Gingrich reforms. Those need to be undone. And also you need more power in committees, and you probably need fewer cameras in committees. The most functional congressional committees are the ones that spend the least time on camera, the intelligence committees and so on, and that's probably not a coincidence. It's not entirely because of the absence of cameras, but that doesn't hurt. So those are the sorts of reforms I would start with, is anything that brings more power to the committees out of the leadership office. And beyond that, you've got to ask Phil Wallach and Kevin Kosar at AEI. They would know better than me.
Regarding decrees, what about the major questions
Yes.
doctrine? Where did that come from, and what do you think of it?
Okay, so for the non-lawyers in the room, the major questions doctrine is this. When an agency suddenly discovers that it has immense power to promulgate transformative regulations on the most important, a transformative regulatory program on the most important issues of our time. Wow, we can fix climate change. It's right there in the Clean Air Act of 1990. Wow, we can, what's that? Well, the 1990s was the amendments. That was the, but you're right, 1970 even. Or, sure, we can reform all internet regulation. It's right there in the Communications Act of 1934. Or as the Clinton administration did when this doctrine first started to bubble up, yeah, we can regulate or outlaw cigarettes. It's right there in the Food and Drug Act, even though Congress had been rejecting legislation on that issue for 60 years. Anytime an agency suddenly discovers unprecedented transformative regulatory powers in a long-standing statute on the most consequential issues of our time, the so-called major questions, the Roberts Court now says, we're going to be skeptical. We're not saying the agency can't do it, but they have to point to very specific legislative text on the subject. And so we're going to construe statutes. When in doubt, we're going to construe the statute to not allow that agency program. We're going to presume that Congress reserved that kind of decision for itself, which may or may not be an accurate presumption, but it's the one that the courts are sort of ascribing to Congress in the hopes of making Congress a better version of itself, pretending that Congress was a better version of itself and hoping that'll inspire Congress to actually become that version of itself. So I quite like it.
Who had that idea?
For the major questions doctrine?
Yeah.
Well, it arose, the first case to really frame things, the first modern case to frame things in these terms was the challenge to the FDA's tobacco regulations. That opinion was written, I think, by Chief Justice Rehnquist. Might not have been. Was it O'Connor? You're right, Shep. So it was Justice O'Connor's great idea. Rehnquist.
She used the words actually.
She did not. She did not. But in that case, a case in the early '80s involving benzene, where then Justice Rehnquist had a good opinion, and a few others, they kept offering this sentiment, but never using the term major questions. Justice Breyer, former, I'm told now, PCG Speaker Stephen Breyer, offered a version of that either when he was a First Circuit judge or maybe when he was still a Harvard law professor. But over time, the lawyers, including my late great mentor, C. Boyden Gray, started talking about the so-called major questions doctrine. And finally, the name stuck. I think the Supreme Court finally accepted the label recently. And now they're arguing over what counts as major.
Well, but the question is that still relevant with the overturning of Chevron? Yeah. Isn't every question a major question now?
No, I don't think so. There's lots of minor questions. Usually the lawyers get paid the most for the minor questions. But there's a lot of minor questions. Let me describe it in these terms, Paul. Because I think what you're saying is, in the aftermath of Chevron deference, doesn't that mean that agencies are never going to get the benefit of the doubt anymore? And I don't think that's entirely right. My reading of what the court did in getting rid of Chevron deference is that it's now harder for agencies to flip-flop in either a regulatory or a deregulatory direction. That if there's a long-standing set of regulations and a future version of the Reagan administration wants to suddenly start deregulating somewhere, the courts will be skeptical of that. The major questions doctrine itself really cuts only in one direction. It really is a check against pro-regulatory administrations, I think. It's too soon to tell. I tell people when they ask, what's this mean, the end of Chevron deference? I say, it's too soon to tell. It took us 40 years to figure out what was in Chevron deference, and it'll take us at least, maybe not 40 years, but 40 months to figure out what was there in the end of Chevron, in Loper-Bright.
Adam, do you have a sense that these things are happening in other countries or within the European Union, this shift of, I know so little about this topic, but I recall even 20 years ago that, that Germany and the EU seem to be increasingly the same problems of some kind of shifting of power, of centralization and a commission and these kinds of things. So that would speak to the point of that this is somewhat inevitable, that these institutions, if they're successful, they will start usurping each other in a way.
I don't know. In some ways, I'm told over and over again that what we're seeing in administration today is a return to parliamentary government in the U.S. And to that extent, I guess the U.S. is catching up with Europe from a couple of centuries ago. In terms of what's happening now, it's actually a mixed bag in Europe. I don't pretend to be an expert of what's happening in Europe. But in regulation, I'm told that even in the European Commission, you're seeing efforts to slow the pace of change in regulation. Some of the things the Trump administration did early on in regulatory cost-benefit analysis and regulatory budgets and so on, it was modeled on what was done in the European Commission and the UK and Canada. Actually, Michael Kinsley once said, the most boring headline is Canada proposes new initiative or something like this, successful Canadian initiative. And in some ways, a lot of the Trump cost-benefit stuff was a successful Canadian initiative. They were following what Canada does on regulatory budgeting. I don't know about the structural themes, though, as much on administration. I will say one of the ironies of serving on the court commission, though, on the judicial side of this, is that in the moment when we were wrapping up our deliberations on whether or not the courts ought to be reformed, so to speak, Secretary Blinken was in Latin America calling on those countries to not pack their Supreme Courts or restructure their Supreme Courts. And so I do know that around the world, and especially today, the politics around courts have never been great. That the United States has always stood out in the stability of its judicial system, Of course, it's a good thing. Hamilton said that we would need our independent judges all the more in a republic as opposed to other forms of government. And so I'm glad the United States is not following those trends, and I'm glad that we still stand as an example against those trends. I do miss the days, I'll say, when I would read the Journal of Democracy for its analysis of what was happening overseas, rather than as an account of what's happening here at home.
Well, virtue is your panacea, but given how we've been in declining virtue,
Yeah.
most of us would agree with that. And I don't know if you're religious or not, but do you see this turning around and virtue becoming more a part of our politics and discussion?
Yeah, I'm religious. I'm Catholic. When I talk about virtue in this context, I'm glad you asked. I don't mean it that way. I'm not against virtue that way. I'm just not. What I'm talking about here is the kind of thing that Madison referred to in, what was it, Federalist 55, when he said Republican government in the context of Congress presupposes certain virtues among our representatives more than any other form of government. It's the same thing that Hamilton alludes to in Federalist 78, where he says we need life tenure for judges in order to attract judges with the right qualifications. And of course, there's no qualifications in the Constitution other than presidential appointment and Senate confirmation. But Hamilton knew that there were other qualifications, so to speak. There were qualifications of temperament as much as anything. The reason why at the end of my talk I hark on Republican virtue is that we need a return to that discussion here. And it's not just a set of virtues that cuts across all branches of government and the people themselves equally. It's not Bill Bennett's Book of Virtues as applied to Washington, D.C. It's understanding and really speaking in terms of the virtues of a president versus a member of Congress versus a judge. Why John Marshall? What made him a mediocre member of Congress but the great Chief Justice? What made Alexander Hamilton a great executive but he would have been a terrible senator? Is actually thinking in those terms and speaking in those terms. I wouldn't bring it up if I thought it was hopeless. Maybe it's hopeless, but I don't think it is. I think first and foremost, that vocabulary could help inform the work of the Supreme Court as it tries to make the administration more administrative. It's impossible for the court to draw clear, principled lines between a law that delegates too much power to the executive branch versus a law that delegates a lot of power, but not an unconstitutional amount of power to the executive branch. No such line exists. The only way the court, I think, is going to be able to intuit the right decision in particular cases is to try to think about whether Congress's law is demanding that a president act more like an executive or more like a legislature. The only way we're going to actually come up with a functional difference between what's a legislative power and what's an executive power is not in the words on the statute, but in the cast of mind and temperament and quality of temperament that it demands of the executive branch. And so that's where I would start with this.
It's temperament more than virtue.
Yeah, that's right. That's right. I know that I know Professor Pangle has written a lot on this, and I've learned a lot from it. And I wish people would return to those writings, especially the lawyers.
This is the last question, Avi.
Who's gonna win on Tuesday? And what do you have any fears about a potential result? I'm more interested in the first question than the second.
Who's going to win? Well, America, of course, right? I don't have the foggiest idea. I've been convinced since the moment the prices skyrocketed almost 20% in a year and a half that President Trump would win the next election. President Trump's entire campaign seems to rely disproportionately on young male voters who are probably the least reliable voters at all. And the most energized voters are right now seem to be women and young women who have a lot on the line and a lot of political energy and who tend to prefer group projects more than men do. And so I'd say I was betting on inflation to put President Trump in office. If I had to bet right now, I suppose I'd bet on women to put Kamala Harris in office. What I'm worried about, I don't know. I got my hair cut a couple of days ago, just down the street from the White House, and my barber told me that they were going to have to board up the windows. So I do worry about what's going to happen after Election Day, and what it's going to do in downtown Washington, and what it's going to do more broadly.
And beyond the immediate perhaps violent aftermath, do you have concerns about what the results of the election could portend for the country for the next few years? You're talking about it. Oh, I'm sorry.
I'm always concerned.
Well, we've had a semester's worth of information and analysis. Thank you so much, Adam.
Thank you. Thank you.